Hey, good morning. This is Michael Jurista from Jurista Law LLC. I wanted to take an opportunity during this hot weather we're experiencing here in New Jersey to talk about a recent case decided by the New Jersey Supreme Court, which could help cool us down. That case was Pareja versus Princton International. It's a case which is very beneficial for commercial landlords here in New Jersey. And in that case, New Jersey has adopted what's called the ongoing storm rule. And in layman's terms, basically what that means is that New Jersey has concluded, like similar states, that when a storm is ongoing, for example, a snowstorm or something like that, that a landlord does not have an obligation to clean up the snow or prevent injuries from ice or something like that while the storm is ongoing. There's many jurisdictions that say that the landlord has to do this while the storm is going, either put salt down or something like that. But currently in New Jersey, as a result of this recent decision by the New Jersey Supreme Court, commercial landlords do not have to take any action to protect pedestrians while the storm is ongoing. This is very important. One of the things they relied upon is, although other jurisdictions have ruled other ways, is that they look to other states in the area: New York, Connecticut, Delaware, Pennsylvania. These are all cases that have adopted the ongoing storm rule. Being the climate the same as those states, New Jersey is going to follow that lead for commercial landlords. Now, it's not all bad news for pedestrians and tenants of these commercial properties. New Jersey Supreme Court was clear to state that there are exceptions to this rule. One being that the commercial landlord's conduct or their actions somehow increased the risk to the pedestrian, which resulted in the injury. This could be, for example, they cited an issue where the commercial landlord required people to park far away and they had to walk through the snow or something like that, and the person was injured. That would not be a circumstance where the landlord would be protected. The other is where a danger is pre-existing, and that involves where there might be a prior snowstorm or something like that that the landlord did not clean up. And the other thing that the Supreme Court was quick to state, to the benefit of pedestrians and tenants, is that while this is now the law in New Jersey, they are not preventing juries from considering evidence which would get to these exceptions, such as, when the snow fell before, whether there was when the storm ended, what else was on the property, what other types of incidents created the injury or something like that. So while this is the rule in New Jersey, it seems like they're interpreting it more as a presumption than anything else. So there certainly is protection for commercial landlords, and they should definitely pay attention to this when the snow falls in the winter. Granted, that being said, I would recommend to any of my commercial landlord tenants that if you do have the feasibility to clean up and keep everybody safe, you should certainly take advantage of that. There's no reason to take any risk nor try to see how this case is interpreted. I wouldn't want one of my clients to be the first one to test this out in the lower court. So if you have any questions, if you want to reach out for any advice, please feel free to visit my website or contact me. The links are below the video. Thanks again.